Okay, welcome everyone, and thank you so much for taking part in this seminar. I am Carlo Casonato, and I will give a brief introduction to the topic, and then I'll give the floor to Lucia Busatta, who will chair the meeting. Well, as you know, today's topic is end-of-life decision from a comparative perspective, and we will focus on assisted suicide and euthanasia in Canada, Germany, Austria, and Spain. I mean, we choose these countries because these are perhaps the most interesting legal systems nowadays. But more generally speaking, for some years now, and in many countries, there has been a trend, a kind of common trend, to give people more autonomy, more self-determination in their lives, and also at the end of their lives. Actually, we organized this seminar because it seemed to us that this trend, this opening trend, is accelerating in recent times. Let me just mention 3 examples taken from last week's news. First, in the UK, the health secretary seems to be changing his mind and to support the legalization of assisted suicide after the death of Sir Paul Cosford. Paul Cosford was the former medical director of Public Health England, and Sir Cosford suffered from cancer, and he died after writing in the British Medical Journal, in the British Medical Journal, that the lack of control over his death was, and I quote, inhumane. Second example, in Germany, after the Bundesverfassungsgericht judgment, Professor Esther Appacher will speak about that, the Medical Association dropped the opposition to assisted suicide. In fact, the German Doctors' National Congress voted to amend the code of conduct accordingly, so allowing doctors to help people take their own life. Third example, South Australia. South Australia Upper House voted last week for the legalization of assisted suicide and euthanasia. And if the bill will be confirmed in the lower house, South Australia will be the 4th Australian state where assisted suicide and euthanasia is legal, after Victoria, Western Australia, and Tasmania. Okay, these are just 3 very recent examples confirming that the traditional absolute ban on assisted suicide and on euthanasia is given way to the legal possibility to end one's life in a manner more consistent with one's sense of dignity. In this way, in my view, in my opinion at least, the law is coming closer to the very logic of the constitutional state. I see the legalization of assisted suicide and euthanasia as a step towards the principle of equality, the right not to suffer at the end of life, and to the right to decide for oneself. The right to decide without interference on choices that are truly essential for one's life and one's dignity. So I see this common trend, even though I also see, under a comparative perspective, a number of similarities, but also differences, variables and constants. Let me just mention 2 points on that. First point, who, under this comparative perspective, who is the main actor in this movement of granting more self-determination to people? Well, we know that the main players in this opening usually are judges and or legislatures. Sometimes both of them acting together in the same direction. This was the case in the Netherlands, well, this is the case in Canada. Thomas Mcmurrow will focus on that, or perhaps in Spain, Íñigo de Miguel Berain will focus on that. Sometimes the main actors of this movement are instead just the judges, usually constitutional courts, without any active support by legislatures. In Italy, for instance, and we will see in Austria, Lamis Kazadek will focus on that. Rarely, as much as I know, rarely it has been just the legislatures, acting as the main player in this movement against judges. A case in point could be Portugal, where the Constitutional Tribunal has declared the law on assisted suicide unconstitutional because of its vagueness. From this point of view, who is the actor in this movement? Maybe is worth saying that the professional ethics, the code of conduct, the deontological component of the system, if you like. So this component has always struggled to follow the opening of the law. Okay, in Germany here, there is a movement in this direction, but maybe it is an exception. Usually, code of conduct, the deontological component tried to contrast the legalization of euthanasia. And this, of course, is a big problem. So the first point was about the main player in this movement. The second point, my concluding point, is the content of the law under a comparative perspective. Usually, but here again, with important exceptions, such as Germany again, there are 3 requirements for getting assisted suicide and euthanasia. First, a serious illness. Second, unbearable pain. Third, the informed and current consent of a competent adult. Here again, we have exceptions in Belgium and also in Canada. There is an ongoing debate on considering living wills given by people who eventually will develop, a status of dementia, for instance. In all cases, dealing with the content of the law provides for a strict procedure in order to obtain euthanasia, which so far, at least in my opinion, have avoided the risk of abuse and have avoided the risk of the death of vulnerable people. So what I see, more generally from this comparative perspective is a general and quite common trend towards granting more self-determination to people, with a number of similarities and differences from a comparative perspective, with many constants, but also a few variables. I don't know if Professor Tania Groppi, who will draw the concluding remarks, agrees on that. There are also a number of issues, a number of problems. We spoke just last week, we talked about the problems in the enforcement in Italy of the decision of our Italian Corte Costituzionale that made assisted suicide legal, but there are a number of very serious problems in enforcing, in applying the judgment. So there are pros and cons as usual, but I don't want to waste too much time. I just want to introduce a bit the topic, giving some coordinates of it as I see them. So I don't want to waste too much time. Now it's time to hear from our speakers, whom I thank very much. So Lucia, you have the floor in order to introduce them. Thanks a lot to everybody. Lucia, you have the floor.
Thank you very much. Good evening, everybody, and welcome to this seminar on the latest news about end-of-life issues in Europe and in North America. I have the pleasure of leaving the floor to our distinguished guests. The first one is Professor Thomas Mcmurrow from Canada. He's Associate Professor of Legal Studies at the Ontario Tech University, and he is very, very expert on issues related to end-of-life laws and case law in North America. So please, Thomas, you have the floor.
Thank you so much, Lucia, and thank you also, Carlo. It's wonderful to be here today and to join such distinguished fellow panelists. I hope Lucia's overly generous introduction won't set you up for disappointment, but there are certain features of the American and Canadian context that I'd like to highlight in my short period of time, and I'm going to share my screen now, and I have a PowerPoint that I hope you can see there.
Yep, perfect.
Okay, terrific. So yeah, so I've been asked to provide a snapshot of Canada and the United States when it comes to end-of-life decisions. In particular, as Carlo mentioned, voluntary euthanasia and assisted suicide, or what is sometimes termed as physician-administered or self-administered assisted dying. So in the United States, 9 of the 50 states and the District of Columbia, DC, Washington, DC, they've legalized assisted dying. And it started in, there's a list of the states there, and there's an asterisk beside Hawaii because pretty much all the laws are identical, except Hawaii's is a bit more restrictive. But all of the laws have followed Oregon's Death with Dignity Act. So that's really provided the blueprint for legislation in these different states throughout the United States. And under Oregon's Death with Dignity Act, you must be terminally ill and you must self-administer the lethal substance, which is prescribed by their physician. So administration by the physician is actually prohibited. And as I'll talk about, that's an important distinction with the way it is in Canada, where although both forms are permitted in Canada, the vast majority of people choose to have the doctor administer the life-terminating substance. So under the Oregon statute, you have to be an adult, 18 or older. You have to be a resident of Oregon. You have to be capable, meaning to make and communicate healthcare decisions. And also, you have to have a terminal illness diagnosis. So that means a prognosis of 6 months. There's 13 more states right now in the US that are currently debating assisted dying legislation. I won't have the opportunity to discuss each of the pieces of legislation there. As Lucia mentioned, my area of interest is primarily Canada, but I think it's helpful to see the contrast with the US. So as I mentioned, both self-administered, which hardly anyone does, and physician, or also nurse practitioner, which is a special designation in the Canadian health system. So it's a nurse, but who is university education, and it's a position that's particularly important in rural and remote communities in Canada because of the shortage of doctors. But so it's both physicians and nurse practitioners who may be made assessors and providers. So the assessor, you have to have 2 assessors, 2 people to say that the patient is eligible, and then one of those assessors will usually then do the provision of MAID. So in Canada, you need to be eligible for government-funded health services. So I mean, that's another background consideration. We contrast the MAID regimes in Canada and the United States. We have to think about how different the health systems are too, where we have publicly funded healthcare in Canada, and that does not exist anywhere near to the same extent across the United States. So you have to be eligible for government-funded healthcare, kind of like the Oregon residency requirement, with an eye to preventing tourism, so-called euthanasia tourism. Again, you have to be 18 years of age and capable of making decisions with respect to health. You also have to be diagnosed not with a terminal illness, not with a prognosis of 6 months, but with a grievous and irremediable medical condition. Your request has to be voluntary, and you have to provide informed consent, which means that you have to have been informed of other means of helping to relieve your suffering. It doesn't mean you have to have tried those, it means you have to know that those exist. So where the changes have come most recently in Canada have been around the definition of grievous and irremediable medical condition. So this was a term that was used in the 2015 Carter decision, which was the Supreme Court of Canada's decision that declared the blanket prohibition on voluntary euthanasia and assisted suicide unconstitutional. So when Parliament responded to that declaration and amended the criminal code, they defined grievous and irremediable medical condition to be a serious and incurable illness, disease, or disability, to be in an advanced state of irreversible decline in capability, and for that illness, disease, or disability to cause physical or psychological suffering that is intolerable to the patient under the circumstances of their condition. And the other thing, and this is different because the Supreme Court of Canada didn't specify this in their Carter ruling. They didn't say it wasn't allowed either, but they added this requirement that one's natural death has become reasonably foreseeable, taking into account all of their medical circumstances without a prognosis necessarily having been made as to the specific length of time that they have remaining. So this standard, which was controversial when it was first introduced in the legislation in 2016, some feeling that, well, there should be a more strict temporal requirement, the prognosis of 6 months, others saying that there shouldn't be any connection with natural death required at all. Well, in 2019, the Quebec Superior Court, in a case involving Jean Trouchon, who's the gentleman on the right, and Nicole Gladu, the woman on the left, they challenged the constitutionality of this requirement, saying that it denied their rights to equality and to the right to life, liberty, and security of the person, and not to be deprived of those accepted in accordance with principles of fundamental justice. So the Quebec Superior Court, which is a court of first instance, right? So in Canada's court structure, this was a trial court decision. Normally, the government would appeal that decision to the Court of Appeal and up to the Supreme Court. That didn't happen here. Instead, both the governments of Quebec and Quebec and Canada accepted the decision, but then they had to figure out, okay, well, how do we draft legislation that is consistent with this ruling, but at the same time that addresses concerns that removing this condition will open things up too much. So Bill C-7 is the piece of legislation which amends the criminal code. And that was just passed in March of this year. So what does it do? Well, it expands eligibility beyond those whose natural death is reasonably foreseeable. It permits a consent waiver in very specific circumstances. You need to have already had your MAID assessment completed. You need to have been approved. In this case, your natural death does have to be reasonably foreseeable. I can expand on the details of that later. And the third thing is it says, okay, we are going to have an explicit exclusion of patients whose sole underlying medical condition is a mental illness. Those patients were excluded under the reasonably foreseeable natural death criterion, but you take that criterion away, and now, if somebody satisfies the other criteria, then if they have no other health condition, but their reason for wanting MAID is because they're suffering with depression or schizophrenia, the law now says, well, they are explicitly excluded, but the law says that this exclusion will expire in 2 years. So in the meantime, they have to figure out if there needs to be additional rules in place, or if they should renew that exclusion 2 years from now, because otherwise it's what's called a sunset clause. It will just expire. So just to kind of highlight, Lucia, perhaps you could show me, I wish I were keeping track of how much time I have left for my 15 minutes, just by your hand. because I don't want to eat into anyone else's time, but I just wanted to highlight that in the United States, the end of life requirement is defined legally and medically as a prognosis of 6 months. Whereas in Canada, more legal power lies with the patient to determine the timing of the end of life with medical assistance. So what we have here, I just wanted to give you 3 scenarios to bear in mind. So imagine a 22-year-old car accident victim who's told that with physical therapy and counseling, he'll learn to adjust to being a paraplegic, but he makes a competent, informed, voluntary request for medical assistance in dying. He waits the new 90-day period that he has to, and he receives MAID. So with Bill C7, this patient, who previously wouldn't have been allowed to receive MAID because of the reasonably foreseeable death requirement, they are now permitted access to MAID. Meanwhile, the second scenario is a 41-year-old divorced mother of 2. She suffered from clinical depression her entire, adult life. She has no other health condition, and the MAID assessors are satisfied that she has capacity and that she's suffering intolerably. So this person, because of the exclusion of mental illness, so underlying condition, they would be excluded. The third case is of a person who, prior to losing capacity from Alzheimer's, in fact, prior to even being diagnosed with Alzheimer's, he expressed his wishes to receive MAID at a moment when he had lost capacity, doesn't recognize his wife and children, and requires assistance in bathing. So he also is excluded from access to MAID because the general requirement is that you give consent at the moment of provision. And then, as I indicated, there's a kind of special set of circumstances where it has to be after the diagnosis, after the assessment, after the approval, and then on a specified date where you receive MAID. So that is new in this legislation. Prior to that, you had to give consent at the moment of provision. The other thing which is new is the explicit exclusion on the grounds of mental illness. But you can see these scenarios, they're still being debated. All of these are prohibited in the United States. The first one is now allowed in Canada. So I think that there's a couple of interesting questions, right? The one of the way in which the criminal law allows or permits assisted dying, and then the question of, well, what should the physician or indeed the subject themselves decide they should do? And so I think that there's an ongoing tension between how this debate takes place on the level of criminal law reform and the level of clinical decision-making standards. And how do you refuse a request for MAID? And I'm not talking about conscience rights, that's another kind of issue, but how does one go about deciding that, in the case of a 22-year-old that, okay, even though you're legally entitled, that this might not actually be the best choice for you? And so I think that the discourse of constitutional rights and criminal prohibitions has really kind of inflected the way in which we think about these as medical questions, but I will leave it there. I don't want to take up too much time, but I thought it'd be helpful to think of a few scenarios, and I realize they're not nearly detailed enough, but just to imagine that these are real situations that individuals and families and clinicians are facing on a daily basis. So thanks very much.
Thank you very much, Thomas. That was really, really interesting and inspiring. And I don't want to lose any time, so we'll have some spare time at the end for the debate. And I give quickly the floor to Professor Esther Hapaka, who is Professor on Constitutional Law, the Faculty of Law of the University of Innsbruck in Austria. She will present us the recent decision by the Bundesverfassungsgericht in Germany. Thank you, Esther. You have the floor.
Thank you, Lucia. Thank you very much, Carlo, for having me today and for letting me join in this very interesting webinar, which puts us in front of, decisions which are life defining. And I think when I just think about my personal situation, I do have parents-in-law who are very old. So, question has come up how they want to die, just to put it very clearly. I'm going to talk about the decision of the Bundesverfassungsgericht of 20 February last year, in which the prohibition of assisted suicide services, which has been laid down in the criminal code, has been declared unconstitutional. I do not have any PowerPoints prepared, so bear with me. Just I'm trying to point out some major points of this decision, which in my view is really, really well, courageous in a certain sense of way. I would like to start with a quick look at the background and the frame in which this paragraph 217 of the Criminal Code has been enacted. What was the background? The background is that in general, in the German legal order, suicide is not punishable, and therefore it is permitted, and therefore assisting in a permitted act cannot be forbidden either, and therefore cannot be made punishable. This was the general situation. As well, as Carlo Casanato already mentioned before, the medical associations were very strict in opposing action of doctors or physicians in assisting suicides. Yeah, because for them it was, on one hand, it was not within the scope of their activities, of their profession. The profession is aiding and not putting a life to end. And as well, in the Code of Conduct, it was differently regulated, but more or less in the Code of Conduct, they were forbidden and were punished if they did leave a person in a life and dangerous situation without interfering. And assisting a suicide is putting a person in the life and dangerous situation, unless this person obviously does not want to have life-saving medical treatment. So in this general frame, in 2015, the legislator tried to enact by the criminal code sort of regulation. Why? Because this situation was feared to bring people to decide unwillingly or pressurized on ending their life by seeking help. So the legislator evaluated this as people being in vulnerable situations, and if there were service offered by organizations to put these people in contact with doctors willing to provide assistance in suicide, then the legislator feared that the pressure on old people, people with illnesses, etc., would be augmented and push them towards asking for this help. So offering services means an offer, more or less sort of economic offer. I mean, some enticing perhaps people to choose to end their life. So that's why in 2015, the paragraph 2017 of the Criminal Code was introduced, making punishable this offering of services by organizations. And these organizations did what? They put people willing to end their life in contact with doctors, physicians willing to help them. But what was the result of this? Perhaps also intended. The result was that it was really, really difficult to obtain assistance in suicide, especially, for example, by getting lethal drugs, which need a prescription, which need a doctor to prescribe them and to also to administer them. That's why persons with serious illness who seeked to end their life and was in need of this sort of assistance challenged this provision, as well as associations offering suicide assistance. Just recall Dignitas, which is also an organization working in Switzerland. But also physicians working in care and also lawyers advising on these suicide matters. And this brought this provision before the Constitutional Court, Bundesverfassungsgericht. And especially, I would like to focus on the arguments of the people with serious illness, because this is really I think this is the core element of this decision. These persons claimed that the provision denies the right to a self-determined death. And this right to a self-determined death is encompassed in the general right of personality, according to Article 2, para 1 of the Basic Law, and in conjunction with the inviolability of human dignity, which is part and is encompassed in Article 1, para 1 of the Basic Law. So, general right to personality, self-determination, and human dignity. These were the core points which these people claimed were violated by criminalizing assisted suicide by organizations, organizations providing services in this field. And the Bundesverfassungsgericht followed this lead and established that there is a right to self-determined death, which is based on the general right of personality and on the inviolability of human dignity. And the Bundesverfassungsgericht found that this right to a self-determined death entails, first, the freedom to take one's own life. And I will come back to this, what this entails in detail. And second, the freedom to seek and, if offered, to utilize the assistance from third parties provided for this purpose. Freedom to take one's life, one's own life, signifies what? Signifies the right to choose in self-determination to take one's own life based on an informed and deliberate decision. And perhaps the questions pointed out by Thomas Mcmurrow before, what about Alzheimer people, for example? Then it implies that individuals can control their life on their own terms. And that means they do not only have the right to refuse life-sustaining treatments, but they have also the right to take actively their own life. And this in all stages of life and illness. This right cannot be limited to specific causes. For example, so only in case of certain illnesses or in a certain advanced stage of an illness, or by motives, as for example, a religious dogma or some norms of society dealing what life and death is the value of life and death. Here the Bundesverfassungsgericht states very clearly that this limiting this right would amount to a predetermination of the motives the person is seeking to end their own life. And there can be no predetermination of these motives. So I do not have to justify my decision to put an end to my life, because every person has another view of what is quality of life, what is a meaningful existence. And the Bundesverfassungsgericht states also very clearly that the self-determined suicide is a direct, even if it's a final expression of the personal autonomy. And personal autonomy is an inherent element of the human dignity. The second profile is this the right to self-determined death, and there is also the freedom to seek and utilize assistance. Why this? Because if the exercise of a fundamental right depends on the involvement of third parties or of on their participation, then the fundamental right has to be protected from a restriction, which is linked to inhibiting those third parties from offering the necessary activities or assistance. And on this basis, the Bundesverfassungsgericht found the Criminal Code provision, paragraph 217, legitimate in its purpose, but not justified. Why legitimate in its purpose? Because the Bundesverfassungsgericht found that the purpose of this provision is legitimate insofar as it is counteracting or trying to counteract a danger that assisted suicide becomes the normal end of the normal way of end one's life. Therefore, creating a situation, potentially very dangerous situation, where social expectations can be put forward to pressure people to end their own life in this way. So, for example, elderly people who do not want to burden their relatives, etc. The Bundesverfassungsgericht states very clearly that to counteract this possible outcome, these influences of the self-determination of people, the legislator has to enact measures, preventive measures, safeguards, for example, by offering more palliative care or by improving living conditions through social policies. But anyway, the legislator cannot enact a regulation that does not leave sufficient space for autonomous self-determination. By saying, okay, you got other options available, so just make use of palliative care, for example, because there is no obligation to use palliative care. And therefore, the Bundesverfassungsgericht said also, you should improve, but this is not the way to justify the limitation of this right of determining one's own death. In conclusion, the central part of the decision is this right to a self-determined death, which cannot be limited by using criteria, but I just call them now material criteria, like it's limited only to those people who are terminally ill or have a life expectancies of 6 months or fall within certain categories predetermined by the legislator. No, it is really encompassing a right to self-determination, even in the end of one's own life. Certainly, the legislator can do now what? The legislator has to act, and Carlo mentioned beforehand that now doctors, physicians have dropped their opposition to regulating these aspects. The Bundestag had, in the end of April, had a general orientational debate where, well, one said, this is a culture of death we are evocating. The other said, we have to try to get a sensible legislation which respects the right to self-determination. Anyway, the Bundesverfassungsgericht put down clearly that the measures directed to ensure protection of the self-determination can encompass providing information, for example, or waiting periods, just to make sure that the decision is genuine, is also free. But you cannot require, as I said before, a certain diagnosis. And you can also not require anybody to assist in a suicide. So if doctors drop their opposition, they cannot be obligated in assisting. It is up to them to decide. And according to this, the code of conduct of the medical association will have been changed in the future to this. So the legislator has, I think, a huge amount of work and reflection beforehand. As for us, normal people, person who perhaps could be also found in the situation of thinking about how to end one's own life, what does it leave us? I think it leaves us also on, we need to reflect on questions like, how can we make sure that the decision is informed and deliberate? This is one of the conditions the Bundesverfassungsgericht put down. And I'm thinking exactly of cases of psychic illness, or cases when life crisis is threatening, and you don't know, perhaps the life crisis will pass. But why deny in this case also the freedom to think about it and perhaps to put an end of one's own life, or dementia, Alzheimer? I think we do have very big challenges, and we have to reflect very, very carefully on it, just to make sure, as the Bundesverfassungsgericht says, to ensure this right to a self-determined death, because this is which is expression of the dignity of the human dignity and of the autonomy of a person. And this, for the Bundesverfassungsgericht, is the highest value encompassed in the basic law. Thank you.
Thank you very much, Esther. We really appreciated your presentation, which is also very important to introduce the presentation on the Austrian decision, because the two are very interlinked. And I am sure that Professor Lamiska will give us a very interesting insight in the Austrian decision. Professor Katkade is Professor of Public Law at the Faculty of Law, University of Innsbruck. So, Lamis, you have the floor. Thank you very much.
Thank you very much again for this invitation. It is a pleasure for me to take part in this seminar, and I've got some slides and I will try to share them with you. If this is going to work now. Yes. Can you see it?
Sure.
Yes, it works. Thank you.
Good. So, in December 2020, the Austrian Constitutional Court had to deal with legal questions concerning the end of life. It was not the first time that the court was approached with such questions. It was, however, the first time that its decision had such serious consequences. Let me begin with the legal status quo. Austria is one of the countries who have a very strict regulation concerning self-determined death. According to the criminal code, it is forbidden to assist in suicide or to induce somebody to commit suicide. And it is also forbidden to kill someone on request. Assisted suicide is understood to have a very broad meaning. Even accompanying a suicidal person to Switzerland or buying a train ticket is included and thus forbidden under penal law. So this is the legal situation. Already in 2016, there were efforts to get the Constitutional Court to review whether these laws comply with the Constitution, in particular with the fundamental rights. Several persons wanted to found an association for assisted suicide services. The authorities prohibited the foundation because its activities, which is assisted suicide, are forbidden under penal law. The applicants applied to the Constitutional Court, which, however, didn't initiate the proceeding to review the law. It simply asserted that the laws were constitutional because the European Court of Human Rights had pronounced that in questions concerning the end of life, the member states have a wide margin of appreciation. In view of all this, the decision of the Constitutional Court concerning the current requests to review the law were highly anticipated. Several persons had applied for a repeal of the laws forbidding self-determined death. The applicants were, and this is quite interesting from the procedural point of view, a doctor, 2 terminally ill people, and 1 healthy person. However, I do not want to go into detail of the procedural side, but I will immediately come to the content of the court's decision. And this decision came along with quite a big surprise, and we could say it was actually quite a bolt from the blue. It was expected that the Constitutional Court would review the law in the light of Article 8 of the European Convention of Human Rights and Article 7 of the Austrian Constitution, which is the principle of equality. However, this was not the case. The court considered several fundamental rights and from them derived a new right, the fundamental right of self-determination. So we can already see the parallels to that the court wanted to draw to the German decision. Now, of course, we do have such a right. It is part of Article 8 of the European Convention on Human Rights. However, what the Constitutional Court did, and what is so new, it created a new and basically independent right. So this new right of self-determination protects the decision of how a person wants to lead her life, and it also protects the decision whether and for what reason a person wants to enter life and whether she wants to ask a person for assistance. So this is the new fundamental right that the Constitutional Court created in its decision. And so this is the yardstick for measuring the relevant legal norms. The first aspect is to check whether the prohibition of assisted suicide is in accordance with the right of self-determination. Of course, this rule is an interference with the right. The interesting question is, can it be justified? Until recently, it was mainly two arguments that were brought forward for the prohibition of assisted suicide. Firstly, it was said that such bans are necessary to protect life. Quite rightly, however, this argument did not convince the court. If one accepts that the individual has a right to decide autonomously for life or for death, it would be quite contradictory to protect him of one of these two options. In addition, there is another important aspect that the court points out. The prohibition of assisted suicide might not reach its aim to protect life. On the contrary, it is rather that the individual might be forced to end his life earlier because he might fear that at a later stage, he will not be able to end his life without assistance. Secondly, what is very often said in favor of prohibitions of assisted suicide, they protect people's autonomy because it might be difficult to ascertain that a decision to commit suicide is really based upon the free will of a person. Now, the Constitutional Court does acknowledge these difficulties, and it also states that vulnerable persons have to be protected. However, it emphasizes that these difficulties do not justify to completely deny the right of self-determination. In fact, there are less severe measures to make sure that a decision to end life was made autonomously. And in this context, the court emphasizes that there are other fields where the law accepts self-determination even though the result can be harmful. Patients are allowed to refuse medical treatment. One can draw up a so-called Patientenverfügung, where even future treatments can be refused in case a person is incapable of giving consent. Of course, one could discuss whether these examples that the court gives are structurally comparable with the prohibition of assisted suicide. They do, however, show that in other fields, the free will of a person is being accepted even though it might result in a person's death. And in these fields, we have, of course, the same problems of ensuring a person's autonomy. And this is obviously problematic in view of assisted suicide, because if there is a right of self-determination, it has to be granted in a way that is not discriminating. Then the court takes up another issue. The right of self-determined death can only be claimed by persons who are able to form a free and self-determined will. Now, this pleonasm leads us to the crucial point of the topic. What is self-autonomy? What is a free will? How can we be sure that a decision to commit suicide is based upon the free and autonomous will of a person? We have to be aware that it is impossible to gain absolute certainty. There are, however, as the court points out, criteria that indicate that the will is free. For example, the decision must be based upon informed consent. Only when one knows about all the circumstances, consequences, and alternatives of the situation, one can make a free and self-determined decision. Furthermore, the decision taken has to be durable. It has to be made sure that the irreversible decision to die is not preliminary. Now, all the criteria that the Constitutional Court names are quite convincing, and they're not new. We know them from the discussion about the Patientenverfügung that I mentioned before. So all these, we could say, procedural criteria help to ensure that the decision a suicidal person has made is based upon a free will. Again, however, the court does not stop here, but makes some further remarks concerning other aspects of autonomy. What affects the decision-making process? The court points out quite a relevant aspect, and here we can also see parallels to the German Bundesverfassungsgericht. Everyone is influenced by social and economic circumstances, here is it. They affect basically all our decisions in life. And of course, this is also and in particular true for the wish to die. If one fears to endure pain or to be a burden to other people, this can certainly affect a suicidal decision. However, the social and economic circumstances are not the same for everyone. And of course, it is impossible to make them equal. But there's one important factor that can be made equal for all. And the court is quite clear in that. Everyone must have access to palliative care. So this is quite an important statement because we know that palliative care is an important factor when people think about their end of life. Nevertheless, by the end of 2019, Austria had only 365 beds for palliative care. So the court formulates positive obligations that are derived from the right of self-determination. So let me give a brief summary on the court's arguments. Firstly, the absolute prohibition of assisted suicide cannot be justified regarding the right of self-determination, although it is a legitimate aim to protect self-autonomy. It is not necessary to do that with an absolute ban. And this is proven by other fields where it is legally accepted to take a decision that can result in the death of a person, and it cannot be justified to deny this when it comes to assisted suicide. And secondly, palliative treatment has to be open for everyone. And all these considerations led the Constitutional Court to the conclusion that the prohibition of assisted suicide is unconstitutional. It is in conflict with the fundamental right of self-determination. So let me now come to the prohibition to induce someone to commit suicide. Keeping in mind what we have said so far, it is quite clear that the Constitutional Court didn't find any legal problems with that. If someone is induced, he didn't make a free decision, and so there is no interference with the right of self-determination. The prohibition is constitutional. And what about killing on request? For procedural reasons, the court didn't review this law. However, it made clear that its considerations on assisted suicide cannot be applied on killing on request. The situation is completely different. So what is the conclusion? The prohibition of assisted suicide was repealed. The court set a deadline for this repeal. It will take effect on the 1st of January next year, and that gives the legislation time to pass new laws that might be necessary. And they will basically have to deal with how to protect vulnerable persons and how to make sure that a decision is based upon a free will. So far, there is no draft law yet. there is only talks going on. And the questions that are being discussed now are basically, how can we make sure that a decision to commit suicide was taken autonomously? What kind of procedure be like? What about waiting periods? Another question, who is allowed to ask for help? Terminally ill people, or, and this is what the Constitutional Court actually suggests, everyone. Who is allowed to help? Doctors, relatives and friends? Is it allowed to ban associations for assisted suicide? In summary, the court's decision is very convincing regarding its result. It is indeed very difficult to justify a complete ban of assisted suicide. From a dogmatic point of view, it is problematic that the court introduced a new constitutional right. The current legal situation could probably have led to the same result. Another point of critique one can make, the court is often not very clear in its statements and sometimes uses quite confusing wordings, which could indicate that the decision was quite controversial within the judges at the court. So all in all, things remain quite exciting, and we will have to see what the upcoming months will bring. Thank you.
Thank you very much, Lamis. That was really, really interesting. Moreover, I don't want to, anticipate the conclusions, but I think that there are already several topics that are emerging as common trends from a comparative point of view. But I don't want to lose time, and I will give the floor to our colleague Inigo de Miguel de Rain, who is well, he works at the University of the Basque Country, and he is an expert in law and the human genome. He works at the Department of Public Law of the University of Basque Country. And Inigo, you have the floor.
Thank you so much, Lucia. I'm trying to share my screen. I guess that now you can see my screen. Can you?
Yes.
Yep. Okay, great. So thank you so much, everyone there, for inviting me to this workshop. That is very interesting. I will try to give you a short presentation about the new situation in Spain that, as I think most of you know right now, we have a totally new situation since on March 18, 2021, the Spanish Parliament ratified the law on euthanasia and assisted suicide, as I will tell you in this presentation. It was quite, a quite wide consensus, 202 votes for, 141 against, and 2 abstentions. But even though the numbers look like, wow, this is something that really looks permanent, I'm not so sure about that, since the parliament indeed was divided, and the left wing vote for the law and the right wing vote against. So I don't really know what's going to happen in the future if circumstances change, even though we all know that it's difficult, that once this has been implemented, it will dramatically change. Let's see. Anyway, we became the 4th European country to legalize euthanasia, and this new law will be applicable from June 25, 2021 onwards. In practice, there might be some problems to begin with this, because there must be a kind of committee supervising all the procedures, and this will depend on the regions. You know that Spain is quite divided in different regions, so they will have a word on this, and the law allows them to take like 3 months once it enters into force to constitute this commission. So it might bring a little bit more time. I don't think that we will see the first procedures in the until winter time, more or less, or anything like that. Maybe a little bit before, but let's see. So we got a kind of a not so long law. It's you get there the name, the Spanish name, that it's called Ley Orgánica 3/2021 de Regulación de la Eutanasia, meaning that at least in the name it's all about euthanasia. It's got a preamble and 5 chapters with 19 articles and 7 dispositores finales, final attachments. And one of them is particularly relevant, in my opinion, since it states that death as a consequence of the provision of assistance in dying will be considered as natural death for all legal consideration, natural death for all purposes. This was introduced especially to avoid issues regarding insurance, okay? But it's quite, curious to see that death is considered to be kind of natural death, and it's quite provoked death in death. Okay, so main characteristics of the law. Well, the law entitles any person who meets the requirement to apply for and be provided with assistance in dying. I will quote here Dr. Juan Manuel Calvo Mangas, who has made a very nice translation of some of the ideas that were in the law, and this means especially that the intervention.
Inigo, this is Lucia speaking. Yes. I'm really sorry to interrupt you, but I am afraid there is a technical problem. We are reading just slide number 5, and we are not reading the others.
Oh, sorry. So I will come back and I will try to share it again. Okay.
Thanks.
Yeah, I will try to do it again and see.
Maybe you didn't share the presentation mode. Yeah.
I don't really know. Maybe it's easier if I do it this way. Okay.
Yeah.
Fantastic. Yeah. So we are here. So the idea is more or less that the intervention that causes the death of a person in a direct and active way, it's what will be given to the patients. Okay. So the idea is that that it will be healthcare personnel who will have to administer a substance that causes death, okay? Or maybe they could also prescribe the substance so that the person cannot administer it to himself or herself, whether in a healthcare center or at home. This has been quite polemic in many ways, because it's supposed that if this procedure happens in a home, for example, the monitoring could not be so good. Okay, so that's one of the things that is creating some polemic in Spain. So the idea is that, as I was telling you before, the law allows both euthanasia and assisted suicide on the basis that certain circumstances apply, and it's conceived as a kind of a right. I mean, it's not only that the state allows people to do so, but compromises to provide the means to do that, okay? And it's part of the services of our social security system. The condition is that the patient must be a victim of a serious and incurable disease or a serious chronic and incapacitating disease in the term established by law and certified by the referring physician. So please keep in mind that it's not absolutely necessary that that the patient is suffering for a kind of disease that will cause him or her death. It's enough if it's a kind of chronic and incapacitating disease. So that's why I'm telling you that it's not only about euthanasia, but a wide concept that also includes assisted suicides. But it's also true, on the other hand, that there must be a kind of physical condition somewhere in there. I mean, it's not enough with someone telling you that, oh, sorry, I don't want to live anymore, I'm tired of living, or anything like that. Even though it's true that the idea of a kind of physical disease or a kind of disease that is in there, it could also be psychological, but there must be a kind of disease. It's difficult to really make sure whether it refers to something that is to be diagnosed by a physician, but it looks like. So the main requirement to apply for euthanasia is the age. Minors are excluded in our law, only those who are 18 or more. They must be Spanish citizens or legally residents in Spain. This means that they must give proof of being here in Spain at least 12 months before the request. They must be capable and conscious at the time of making the request. However, requests made via living will are accepted, meaning that if you have introduced that in your living will, then the physician should start with the procedure. And it could also happen that you have named someone else to be your representative. And if your representative asks for the start of the procedure, this could also work, okay? So requests should be written and signed by the patient unless conditions make it impossible. In those cases, a caregiver could sign on their behalf, but a physician, the corresponding physician, should act as a kind of a witness, okay, of that part. The law requests two written requests that must be produced 2 weeks apart. And if the patient referring physician considers that the vital prognosis or the probable duration of the preservation of autonomy is less than this period, they may accept a shorter period. That's more or less what we have. And I could give you further details on that if need be. The patient must give informed consent prior to receiving the assisted termination of life, and this consent must be included in the records, as I was telling you. Only exception is when he cannot or she cannot, but there's a kind of living will that it's asking for. There are some safeguards that have been introduced by our law. First is that the patient that makes the initial request must be informed by the corresponding physician about the diagnosis, the therapeutic possibilities, and the expected prognosis, as well as the possibilities of palliative care, okay? Then after confirmation by the patient, there's a second request, and the patient will meet again with the physician in between those. Then the physician will be required to consult a physician, another physician specializing in the patient's pathology, not belonging to the same care team, so that he or she can validate the request. And finally, there must be a panel of experts composed by a physician and a lawyer who will give the final green light. These two experts will be appointed by the regional commission that I was mentioning before. Okay? And finally, our law introduced some a quite important clause, that's a concept of objection of health professionals. So in principle, health professionals directly involved in the provision of aid in dying may exercise the right to consensus objection. Refusal to perform this service for reason of consent is an individual decision of the health professional directly involved, which must be expressed in advance and in writing. It is important to underline that in Spain, it does not exist a kind of institutional consensus objection, meaning that it can only be individual health caregivers who can really ask for this kind of objection, okay? It's quite controversial whether those physicians or all caregivers could ask for this, or only those who are directly involved in the procedure. It also happens that we are in doubt on whether the physician who is taking care of a patient knows that he or she is willing to ask for the initial of the starting of the procedure, could not proceed with that on the basis of a consent objection. In my opinion, they cannot. I mean, they should start the procedure and then say, no, but sorry, I'm not. I will not go on with this because I made my objection. So the health administration shall create a registry of health professionals who are consensus objections for management purposes, And this is supposed to be subject to the principle of strict confidentiality and personal data protection regulations. It's not so clear to me why is it that they should be or they should ask for conscientious objection before having a case. In general, the Spanish law has not allowed for a kind of change in conscience that I'm not really sure of why it is not possible. But in principle, it seems that if they have not really said nothing about conscious objection before, they cannot really give up the procedure. Okay, that seems quite strange to me. I don't know how you can oblige a caregiver to follow with that if they're not willing to. So it's more or less what we have. It's also, if I could tell you something like kind of doubts or more than what I've said before, or the kind of critical that it's very common in Spain at this moment is that maybe you are aware of this, maybe you are not, but in Spain we have serious issues with palliative care services, meaning that lots of people who are asking for palliative care cannot gain access to that. So one of the main polemics that we have in Spain is whether this will really be a good law in the sense that all those who will be asking for euthanasia or assisted suicide will be really, making an informed consent decision on that, because it, at least in my opinion, you cannot compare the situation on all the possible situation if you cannot make a decision once you have had good access to palliative care. Well, it seems that it's not really such a free consent in several ways. So that's one of the things that we have in there. And of course, it might also happen that some people somehow ask for euthanasia just to gain this access to palliative care, because in the type of records or clinical records and in the petition for the euthanasia, those who are responsible for the patient have to include a kind of report of the access to palliative care that they have had, and they plan to introduce anything like that if need be. So in somehow a petition for euthanasia could trigger the procedure to have a better palliative care. So it's quite tricky in some ways. I mean, maybe it's just me who is thinking about that, but if I had someone who is not having this good access to palliative care, I would, advise him or her to do so. And of course, you could always renounce to the euthanasia at any point of the procedure. I mean, it means nothing that you have asked for that a lot of times and so on. It's just that you can always change your mind and refuse. Okay, so it is more or less that this is what we have in Spain. Of course, we have a very nice national debate. Another thing that has been put on the table is that, of course, this does not seem to be the best moment to introduce a kind of law regarding euthanasia due to the pandemic and the almost impossibility that we have had in Spain to have this kind of stretched contact between physicians and patients. So it's quite difficult in so many ways to implement it in a quite adequate way at this moment. But I guess that in some months, circumstances will change and we will see what happens in Spain. At this moment, we got a lot of doubts in mind, of course, and probably they will be somehow clarified in the next months. That's all I can tell you from at this moment. So thank you very much for your attention. I hope this has been enough, more or less, and I hope that we will have a nice debate. Okay, so thank you again, Lucia, and I give you back the voice.
Thank you very much, Inigo. It is always a pleasure to have you here with us. And once again, thanks a lot to all of our speakers of tonight's seminar, because we are perfectly on time. And thanks to this, and I'm saying this because normally I'm the worst one in respecting the timing of presentations. And thanks to your sharpness, we have like 10 minutes for a quick debate. So if somebody from the audience has any question, I really appreciate if you could write them in the chat, because as we are recording, otherwise I would have to ask to any single interventor to sign a form or to some other very annoying stuff. So please, if anyone has any question, don't be shy and write them in the chat, and I will ask this question to our speakers. And to break the ice, I have one first consideration to share with you and to ask you whether you are sharing my same feelings. I see that we are in front of a path. I would say that the countries we have been discussing tonight, and Italy as well, are on a path, are working I would say on a mountain route, because even though in some countries such as Italy, Germany, and Austria, we don't have a proper law at the moment, we have decisions by constitutional courts and tribunals. In other countries, we have laws such as Canada, some of the states of the United States. We have already listened to the newly approved Spanish law, but I think that a very common feature for all these countries is that they all are working towards complicated decisions and complicated procedures. And my opinion is that nothing is definite and everything has to be put under discussion, as the example from Canada, for example, showed us. So my consideration for you is this one. You all have been longly discussing about the emergence of the individual right, the right to ask for assisted suicide, the right to have a dignified death. But my question is, how would you assess the role of public powers towards assisted suicide? You have been discussing the role of the lawmaker, which is really important, of course, because the lawmaker decides the rules, the procedures, the requirements to make this right effective. But how would you assess the role of healthcare structures and healthcare organization in the state towards the granting of these rights? And this was my question, and then we have two questions in the chat, one from Carlo and the other one, Carlo Casanato, and the other one from Tania Grotti.
Tania, go ahead. I will be
Okay, thank you very much, Carlo. Thank you very much, Lucia, and to all the speakers. I didn't know if I were allowed to ask questions, as I have my own role in this meeting, but then I said, okay, probably I can. Then thank you very much, Lucia. I have a question, especially for Lamis, but probably not only for her, but I'm really interested in this decision of the Constitutional Court of Austria, and especially in the possibility to assess the influence of the German previous decision. Then the question is, because I didn't know this decision, and then I didn't have the time to review the translation, if there is an English translation, if there are some explicit references to the German case, or if you can detect, you already said that there are probably some, there are some links. However, this is a question, but probably I can also ask to our Canadian colleague that presented this comparison between Canada and US, a question about the influence between the two countries, especially in courts. If you can tell us something about this possibility of detecting some influences, then this is a question to Thomas. Thank you.
I don't know, at this point, we don't have any other questions in the chat. So Carlo, would you like to ask your question, and then I leave the floor to our speakers?
Sure, sure. Thanks a lot. Really, really a lot of food for thought. I see here kind of three tensions, three problems. First, we studying comparative law, we are familiar with the tension between law in the books and law in action. Here we have constitutional law in the books and a kind of law in action, which is in a few countries, in Italy for sure, but also maybe in Germany and in Austria. We have constitutional principles, very clear constitutional principles, which are not enforced yet, maybe yet. And here I see, I mentioned it in my very brief introduction, here I see a strong role and also a strong responsibility for medical association. So, for instance, in Italy, they didn't amend the code of conduct. They just add a footnote to the article, which remains forbidding, you know, with a blanket prohibition to any act directly provoking the death of the patient. So, what do you think? I mean, is this something that is going to create a specific problem? This you know, distinction between constitutional law in the books and law in action. First, second, the second tension, the second problem I see considers, I mean, revolve around the principle of equality. When you recognize self-determination, it is, you know, when you base euthanasia or assisted suicide on self-determination, it is very difficult to draw the line. I mean, I see a tendency, a trend to open up the requirements and make the law, it kind of, you know, run towards euthanasia without any medical requisite, any medical condition, based only on self-determination, as, you know, the Bundesverfassungsgericht did, with a, you know, a very crystal and consistent decision, but also arising a number of problems dealing with, you know, how can you actually prove the self-determination and all the other stuff that also Lemis mentioned. So can we reasonably draw a line in the euthanasia, you know, domain, or we have just to be consistent, to be, you know, legally accurate we have to open up everything based only on the self-determination basis. Third, since I know we cannot be sure about a genuine free will. Lamis, mentioned this, but there is always this this kind of background. You cannot be sure that the patient is, expressing his or her genuine free will. Okay, in front of this uncertainty, the law decides to limit the domains of self-determination based on medical condition, not just for other reason or without the medical condition requisite, with the exception of the Bundesverfassungsgericht again. And we'll see. I mean, here I see. I think that the ongoing debate in Canada is very, very interesting because linked with the principle of equality. When you draw the line, you try. I mean, it's kind of a normal trend to go beyond and beyond and beyond in order to assure the principle of equality. So again, can we reasonably draw a rational line without taking the German in kind of the German decision to open up everything based only on self-determination? Thanks.
So the floor is to our speakers. I would use the inverse order as the traditional. So Inigo, would you like to start with the answers?
Yeah, indeed. Well, I think that Carlos made your point that we always have in mind. I mean, at some point, it always seemed weird to me that you need to have a kind of medical condition to be allowed to, to suicide or to ask for assisted suicide or euthanasia or whatever. I mean, I don't really know why we always consider that this is key in the decision. At least in Spain, it happens. So you need to have a kind of physician, that is really assessing that, yeah, you can proceed or anything like that. So the first issue that I have is that I'm not so sure on whether self-determination is the only pillar for anything like that. In Spain, it is not, of course. If you don't have this kind of condition, you will not be able. And one of the things that really seems quite well to me is that, for example, we accept that someone who is suffering a kind of really, unbearable pain, a really terrible pain, who is asking for anything like that, is really, somehow giving consent. This is quite hard to understand in some ways because it might happen that he or her condition are so terrible that the real freedom to make a decision is not so real in so many ways. It's too conditioned by the pain that they are suffering. And but if there is not such kind of medical condition, it's quite curious because it could come someone telling you, no, I don't want to live. It's just because I don't like living. Okay. Somehow I think that someone who's telling you something like this and is not really suffering from a kind, of medical condition, but someone who doesn't like life or who is tired of living or anything like that, that will be a much more free consent in so many ways. But we are much more keen on accepting that the first one really, is really has a right to end up with their life, and the second one instead does not. And this is quite surprising to me in some ways. And a part of me is somehow considering that we are giving too much weight to medical conditions and the role of the physicians telling something like that. I don't know if I have answered Carlo, but I think that somehow this is a kind of follow-up to what he's saying. I don't know if this has to do with self-determination, but I'm quite sure that at least in Spain, the role to be played by physicians is quite strong, or it's quite astonishing that if they are not involved, your will not be considered. That's what I could tell you at this first stage.
Thanks a lot, Inigo. That was really clear. La Miss, would you like to tell us something?
Yes, thank you very much. Let me start with the first question. Thank you, Tanya, for this very interesting question. This is a very good point, because this is what makes the decision from the Constitutional Court, from the Verfassungsgerichtshof, so very interesting. It took him a really long time to decide. I think it's been almost a year, and everyone was expecting the decision, and it was postponed. And then the decision came. And there are so many parallels to the Bundesverfassungsgericht, but the Verfassungsgerichtshof doesn't mention this explicitly. But nevertheless, they can't be overseen. I mean, the first interesting thing is that the Verfassungsgerichtshof talks of this right of self-determination, which the Bundesverfassungsgericht does as well, but the legal situation in Germany is different. In Germany, we have this Persönlichkeitsrecht, we have this right to human dignity. In Austria, we don't have these laws. So we do have the European Convention on Human Rights, but we don't have something that's comparable to the Grundgesetz. So this is why it's so interesting that the Verfassungsgerichtshof created a new right, quite parallel to the German right. So that's what makes it really, well, as I said, it was such a big surprise. What's maybe a little difference in Germany, we had the partial prohibition of assisted suicide. In Austria, we had the complete ban of assisted suicide. So that's why we are not quite sure what the consequences are going to be. What the people are discussing now, is it allowed to foresee a partial ban of assisted suicide? Or do we have to open it? Basically, that's what's being discussed now. No? I think once the Constitutional Court started with this right of self-determination, there is hardly a way out, because when you say, look, you have a right of self-determination, you can't limit it to kind of certain spheres of life, because you can't say, oh, you don't want to live, but you're not ill, but I don't accept this. When I tell the people you have a right of self-determination. So that's a really big conflict we're in. Yeah, and I can see this problem. I don't know how to solve it, but once you're walking the path of self-determination, it's very difficult to kind of find a way out here. The only possible way is to say we have to make sure that it is a self-determined will. So then we can start of thinking maybe the prohibitions have to be different, whether it's a terminally ill people or whether it's someone who is young and who is healthy. So the waiting periods might be different. So I think that this is probably going to be what the law is going to look like, because again, when you accept there is a right of self-determination, then it's not really very consistent to limit it only to spheres where someone is ill. And another thing what's very interesting, what's been mentioned before, what the Constitutional Court in Austria did, which is a really interesting parallel to Germany, it mentioned human dignity. This is so very interesting because in Austria, unlike to Germany, we don't have an explicit law telling people you have your human dignity. This is a fundamental right. Of course, it is, we accept human dignity, but other to Germany, we don't have an explicit law stating this. And the Constitutional Court is always very, very reserved in mentioning human dignity. Now, in this decision, he kind of frequently mentions it. And what he does, he says, everyone decides what his dignity is. So that's part of your free will, to decide what your personal dignity is. And then what he says is, he kind of puts an equal to human dignity and self-determined death. What the Constitutional Court says is, only when you can freely decide upon your end of life is in conformity with the human dignity. So that's a very interesting conclusion that the Constitutional Court draws. And this is definitely going to cause very many questions now when we are drawing up the new law, because exactly as you stated, Carlo, where are the borders? How can we make sure that it's self-determination, but we don't open everything to everyone at any time? Yeah, thank you.
Thank you very much indeed. Esther, would you like to add something?
Well, I think I do not want to add anything on what Lamis said, because I think the problems apply as well now to the German, to the application or of the German decision. I wanted to point out that anyway, the request, killing on request is forbidden in Germany. It remains, it's explicitly forbidden by the criminal law. So perhaps this was was also a reason why the Bundesverfassungsgericht was such open as far as assisted suicide or assisting in death was concerned, because it is still and it remains forbidden. It was not challenged to have a killing on request. So what I think is that certainly the role of the physicians, of the medical associations, will be a very strong one. Just think about it, if if people with psychological problems or with illnesses, what they do, they go to their doctor. And so I think that doctors have a very great influence in contributing on the will people may then formulate or may just find out of the self-determination of people. So I think that the willingness now shown by the medical association, by the Bundesärztekammer, is a very, very strong signal that they are going to think about it and to try to find a way in preserving the dignity of their patients and in contributing to self-determination and autonomy of these people. May I just point out that the Bundesverfassungsgericht also did a comparative survey of the legal situation in various countries: Switzerland, Netherlands, Belgium, Canada, Ontario. So the Bundesverfassungsgericht became comparatist and had a look at other regulations, and this perhaps also influenced the decision, and this broad approach and the definite, very clear outline of this right of self-determination of this aspect.
Excuse me, Esther, is this very unusual? I mean, the comparative approach, or it was the...
No, they're doing this some, but it is, look, I counted the pages, and it's on 5 pages. They really go into detail. So that means that they considered what can be stated. Mm-hmm.
This is really a key point for our considerations tonight. And finally, I leave the floor to Thomas Mcmurrow for any reply, if he has any.
Just a kind of, a couple of brief observations. So picking up on Esther's point about the comparative dimension to the German court's reasoning, I was listening to Lamis describe the reasoning of the Austrian court, and the parallels between the reasoning of the Canadian Supreme Court in 2015 and the Carter decision are remarkable, including this idea of suspending the effect of the decision, which is what the Italian Constitutional Court did too. So I think that's a very interesting area of research to look at. I'm not sure how typical that is of the court in Austria to say, oh, well, this is a matter of rights and the law is unconstitutional, but you can keep it as is until Parliament does something. The other thing that strikes me, or that I thought I'd point out, is that even within Canada, there is still this general prohibition, both on voluntary euthanasia and assisted suicide. So under the criminal code, consent of the victim is still no defense to murder. And assisting someone in their death, if you aren't either a physician or nurse practitioner who has followed all of the steps, that's still a crime as well. And I think that that's another interesting area of research to see, well, given the reasoning that Esther described of, well, if self-termination is just as important as any other form of self-determination, can we continue to justify these other kinds of prohibitions? And I think that this sort of now relates to Lucia's question, which is about, you know, well, who's driving law reform? And I think that if you, and ties in with Tanya's question too, in Canada and the United States, you have very different laws. I think that a key driver in both jurisdictions is civic associations like Death with Dignity. So that's an association in Canada and the United States. And if you contrast their websites, in Canada, there's a much stronger call for liberalization. In the United States, they're not arguing for the Canadian model, and I think that's strategic. And I think that what is extraordinary in this field of study is that, you know, Carlo alluded to the difference between law in the books and law in action. We've witnessed in Canada in the last 6 years how a change in constitutional court decision-making and in legislation can transform the way in which people think about these matters in extraordinary ways. And indeed, you know, we have come to the point where it becomes hard on the basis of an equality argument to justify denying medical assistance and dying to anyone. And so I think that, you know, where we are in Canada is thinking about, well, how well does a constitutional and criminal law discourse serve us now for the kinds of complex ethical questions we have? And I think another area of study of interest is to look at, so what impact does it make on people's lives and decision-making once we change the laws in this way? And I don't know if there's been a lot of longitudinal research on changes in social attitudes and ideas and practices in light of changes, because the changes are kind of just happening right now. So I'll leave it there.
Thanks a lot indeed to all of our guests tonight. And I finally give the floor to Professor Tanya Groppi for drawing some conclusions on this very rich seminar. Professor Tanya Groppi is full professor of public law at the University of Siena in Italy. Thank you very much once again, Tanya.
Thank you very much, Lucia and Carlo, and all the research group based in Trento. And thank you very much to all the speakers for the inspiring presentations. I'm not an expert of this field of law that is, as Carlo knows very well, that is a fascinating field, especially because, as Esther said, it affects also personally all of us in very hard choices. However, I think that is also an important field for of research for comparative lawyers, as it emerged from all the presentations. And I think that the new perspectives we tried to explore a bit today are perspectives that developed especially in the 2 last decades, especially in Western countries. Then we are focusing on a group of Western liberal democracies, and we are looking for similarities, differences in patterns followed, as well as in the decisions themselves. I think it would be interesting also to have a look, to try to consider also other countries in this comparison, beyond liberal democracies and beyond Western legal tradition, in order to try to assess if we can talk of global tendencies or if the tendencies we are considering are limited to a group of countries. And probably this broader perspective than I'm suggesting, Carlo, also this approach, because this could tell us something also about the reasons behind these developments, because very often, and here I'm quoting the Italian Constitutional Court in its very famous decision. This is the 2018 decision, the first. There are two decisions, as you know. The first one in 2018 and next 2019. The court said that the situation the court is facing in the present case was unimaginable at the time when the challenging law was introduced, because of the medical and technological advancement. Then we can have the tendency to link these new perspectives that are showing openness, respect of personal autonomy, dignity, and as Carlos said in the introduction, this tendency to legalization and to eliminate the ban. Okay, we can try have this temptation probably to link this tendency to the medical and technological development, but probably if we look beyond this group of liberal democracies, probably we can try to develop also different explanations for what is going on in our small group of countries. And I think that at a comparative level, this field is also the perfect field to test the dialogue doctrine. You know, the dialogue doctrine in two perspectives: dialogue between courts and legislators from one hand, and from the other hand, the dialogue, vertical and horizontal dialogue between courts, which was developed especially in the round of Aswers. As for the courts and legislators, here, as it has been said, in some countries, a political decision was taken by political majorities. In other countries, legislators had difficulties to evolve, to amend previous laws, especially in the direction of eliminating the criminal provisions, punishing, for example, assisted suicide, and courts had to decide, invalidating provisions aimed at criminalizing some behaviors. Very often giving the legislators some time to decide. This is evident not only in systems such as Germany or Austria, in which the postponement of the effects of the decision is recognized by the legislation, but also in systems as Italy, in which the court is not allowed, according to the legislation, to postpone the effects. And for this reason, for example, the Italian court quoted the Carter decision, the Canadian case, giving time to legislator. I mean, there is this dialogue between courts and legislators in the decision making in this field. Probably there is also a dialogue in the enforcement of the decision that should probably be explored. Then dialogue between courts and legislators. And the second perspective as for dialogue is the dialogue between courts, both at vertical level between national courts and the regional or international courts, and horizontal between domestic courts, especially constitutional courts of different countries. And here probably we didn't develop so much the vertical dialogue here in our debate today. The European Court of Human Rights influence on the national courts on this issue. But my impression, my feeling is that notwithstanding the vast margin of appreciation left by the European Court to the member states, the reasoning and evolving reasoning of the European Court of Human Rights, changing, evolving its approach, probably had an influence also on the evolution of the case law of the constitutional courts in Europe. For sure, this approach is limited to the European regional context. Probably it could be also developed in Latin America in relation to the Inter-American Court, the influence, and this hidden, very often also any hidden influence of especially the influence of the reasoning of the European Court. And as for the horizontal dialogue here, this was my question about the Austrian decision. And it's also interesting what Esther said about Germany. A German constitutional court sometimes consider the comparative approach, not with, although it doesn't apply in the reasoning. But okay, the full picture sometimes is considered. But here is especially well developed as far as Esther told us. And then courts in this field are looking at each other, this is sure, and this is part of the unavoidability of comparative law, what this we know very well. It is very easy to be known. I wonder whether there is also an hidden influence, not explicit, in this horizontal dialogue. Although, for example, the comparison between the Italian and the German decisions shows differences much more than a common tendency or a common approach. And here, in those differences, now I'm not going to develop this point because I would like to conclude. We don't have a lot of time, but comparing especially the German and Italian cases, I wonder whether the influence on the different output is based much more than in different constitutional standards. One could say, okay, Italy doesn't have explicitly the human dignity entrenched in the constitution, German has. But I wonder where it is much more related to the proportionality test. And to the use of the well-developed clear proportionality test. I think that the proportionality test is rather friendly to solutions such as the German solution. Probably I had the possibility to read the Austrian decision, the Austrian case. In Italy, as the Constitutional Court, notwithstanding some recent attempts, never developed properly a proportionality test, the reasoning of the court is rather confused, and probably for this reason, this decision ended up in a solution that for some Italian commentators could appear new and courageous. It isn't compared to the German and the Austrian. And I think that what we really miss in those decisions is especially a clear proportionality test in the reasoning of the court. However, I would like to thank you, all of you, for these really interesting presentations. There are so many aspects that at comparative level we could develop. I learned a lot from you, and for sure I will try to go in depth into this topic. Then thank you very much. Is not a conclusion. We cannot conclude on this topic. It is an ongoing process, as you said, Lucia. Thank you.
Thank you, Tanya. Once again, thank you for all our guests tonight. And actually, it is definitely an ongoing topic. So we really need to meet again, hopefully talking about other countries, to have a global comparison as you proposed. And for today, I have to say goodbye to everybody. Thank you very much to all the people that came to listen to this very interesting seminar. And our next meeting will be next week, May 18th. We will talk about COVID-19 and vaccines. So from all of us, have a very, very nice evening and see you soon.
Okay. Bye-bye.
Thank you. Bye. See you soon.
Bye.
Bye-bye.
Thank you. Thanks a lot. Bye-bye.